Order number 3, sir. In the name of the Honourable Minister of Innovation, Science and Smart Technology, to move the second reading of the Employment Rights Amendment Bill 2019.
Mr. President, I rise to introduce the Employment Rights Amendment Bill 2019, recognizing that the employment relationship is at the base of economic activity of our country, and it is also and should also be at the top of our social effort to ensure the right to work as well as rights at work for our people. The Employment Rights Act, the principal act to which this Employment Rights Amendment Bill refers, was proclaimed in 2013, and it was an attempt to bring greater clarity and balance and precision, among other things, to the employment relationship. It considered a range of rights attendant in modern employee-employer relationships, among them particulars of employment, where place of work, date of a fixed term of contract, when it would end, length of notice, and other particulars had to be spelled out. It considered dismissal, where a person had the right not to be unfairly dismissed for reasons that had nothing to do with their conduct or their capacity to perform duties. It looked at different periods of notice. It also considered the right for an employee to defend him or herself. They should have the opportunity to defend themselves with appropriate representation when accused of wrongdoing. It looked at disciplinary procedures, and of course, it looked at the appointment of a tribunal that would provide recourse in situations where employment relationship ended unsatisfactorily and there was some challenge for compensation or reinstatement or reestablishment. And the Employment Rights Amendment Bill 2019 speaks to this Employment Rights Tribunal in particular. And the purpose of the Employment Rights Tribunal was to consider and determine complaints made under the Act. Its work was meant to be quasi-judicial, meaning that it has the authority to hold hearings and conduct investigations into claims and disputes. It has powers to make decisions and provide remedies in the general manner of courts. Generally speaking, the decisions of the tribunal are final, and appeal is only possible on points of law. Due to the extensive remit of the tribunal and in light of its important function and the weighty responsibility of its members, it was recommended that the members treat their roles with the seriousness it deserves and apply the standard of acumen deserving of the high role, the level of intervention they were expected to make. And so the Employment Rights Amendment Bill therefore provides for members of the Employment Rights Tribunal, which is established under Section 6 of the Principal Employment Rights Act, to take an oath of office or an affirmation of office sworn before the Governor General prior to undertaking duties. Mr. President, this proposed amendment for the taking of oath or affirmations of office does not make for a perfect act. It is recognized that there are regulations to the act that need to be developed. Currently, the chairman and his deputies are examining model regulations from different parts of the world with a view to making recommendations. It is understood also that the way in which the tribunal process functioned in the past was not ideal, and resources were not adequate to ensure enough timely meetings with the right secretarial support. However, this government has now made the effort to improve this situation, especially going into the next financial year with the provision of additional resources. The Employment Rights Act, which was drafted back in 2012, it allowed complainants to take cases before the Employment Rights Tribunal with little or no input from the Chief Labor Officer. It is recognized that the role of the Chief Labor Officer in the process must be revised, and perhaps with a view to giving the CLO, the Chief Labor Officer, greater powers to seek resolution before cases go to the tribunal. Mr. President, this would be a wonderful world if every employer and employee did the right thing by each other every time, where tribunals were a thing of the past. But the human beings are imperfect, and the circumstance of employment relationships is hardly ideal. It is therefore through legislation that we must still regulate the employer-employee relationship to improve working conditions and the life of people at work, such that exploitation, discrimination, mistreatment, and unfairness in its various forms are lessened, if not eliminated. Legislation is also the accepted way to promote best practices which align with our national values and goals. With careful attention to both what we do and how we do it, we have to make sure that those two go together. Because in circumstances such as this, families will not eat, work will not get done, and the country's economy will not grow. And so even as we seek to introduce this small amendment, this simple amendment, as a step in the right direction, we recognize that there is still much more that needs to be done. And we understand that employment and labor law has been gradually developed over the years. Not all was done at one time. And it is with the understanding that this is one progressive step in the right direction, though it does not fix all. It is with that I thank you, and I'm obliged to you, and I beg to move that this bill be read a second time.
Yes, thank you very much, Mr. President. Seeing the lateness of the hour, I will try to be brief, and I will, as much as possible, just touch on a few areas that I think should concern everybody. Sir, this Employment Rights Act was a piece of legislation that had one of the longest gestation periods in modern memory. It took over 10 years to get it right, or to get it. And then when you got it, the government proclaimed it, and then unproclaimed it, and then proclaimed it again. So it had, I've never seen that procedure until, I don't know what it is, but they just, and if you look at the Employment Rights Act, you will see it say corrected copy at the very top. This is because the first copy that they proclaimed, then they changed it and then sent back and proclaimed it again on the 15th of April 2013. They did it in December, then they did it again, but the Governor General said the act commenced on this date. Be that as it may, the act sought to give certain rights to workers. They were long in coming and very much needed, because the law as it stood then says that an employer could dismiss an employee for any reason or for none, as long as he didn't breach his contract. And if you had a contract that says that you can get a month's notice, you give a month's notice, and you could have been dismissed. And that was the interpretation for a long time. even though the Sovereign Employment Act said something otherwise. This act, current act in place, has given workers lots of rights, and for the first time, I embraced them and I was so happy. The problem now comes, sir, it is only like an illusion of rights, because you have all these rights on paper, but you can't access them. Imagine you're going to make a complaint to the Chief Labor Officer. You have been unfairly dismissed. The Chief Labor Officer has 42 days, unless there's some extenuating circumstances, to get the parties together and to conciliate. And if he cannot reach a consensus, the two parties can't reach a consensus, then he's supposed to refer the matter to the Employment Rights Tribunal. I have, speaking personally now, I have 23 cases from National Housing Corporation when the last government sent home those people. And to this day, those 42 days, as far as the Chief Labor Officer is concerned, passed yet. Right? The last administration, remember when they sent home people and walked them to the door and tell them to leave? Those people are still waiting. And we had, as a matter of fact, we had one session before a labor officer. It was adjourned, and we haven't heard anything from them. I wrote, I do everything. The Chief Labor Officer don't know what 42 days look like. I can do a lot more, but I'm being nice today. When the matter gets to the tribunal, sir, as tribunal stage, the tribunals all of a sudden now, they establish themselves like courts, and they want you to file 6 copies of everything, and they want to hear the evidence and stuff. Mr. Chairman, when they first started, I suggested that they should go and check with now Senator Tate, because she ran a tribunal at the National Insurance Sovereign Employment Tribunal. I've appeared before her on a number of occasions. And she makes light work of these issues. The same, and the thing is, she was establishing the same evidence, the same information that these tribunals want. But she did it in a day. These taking years. These tribunals take years. You imagine, they have over 400 cases filed. And to date, sir, they have only done 6 or 7. You know? That is ridiculous. You know? When you appear before Senator and a couple others, but we can't call their name now because I didn't give you permission, they can call hers. But I didn't ask permission, but there's a couple other people who make light work of these sessions at National Insurance and things. I didn't go and get them, you know? Because there's no reason on God's earth why a case should take this long. The next problem that we have, sir, is that the government, and I'm not blaming you guys yet because you just came in and stuff. Well, I was blessed recently. No, but don't worry about that. There's no reason why it should take this long, right? And having taken this long, let me see, I have some cases going back to 2013 that I have not seen the tribunal yet, you know? As I said, when these cases get before the tribunal, the government has not provided enough staff to manage. You can hear 3 cases at a time because the tribunal consists of 9 people, 3 lawyers, and then 6 other people who are appointed on the recommendation of 3 on labor and 3 on the employer side. So you take three of them, 3 persons, one from each group, to make a panel of 3 hair cases. And you would expect that you would have 3 panels working, but you have 1 secretary, 1 transcription clerk. Who's the same person? Yeah, and so you cannot have more than 1 case going on at a time. That is ridiculous. If you set up these things and give people hopes, don't dash them. Because what has happened, and it pains me to see what happens with in some cases. Employers know that the cases will take years. And I have had several cases where the employer said to me, yeah, the body was unfairly dismissed. They're entitled to, they will get $50,000 if they go to the tribunal, but that can take 4 years. I get 25. Or, being go to tribunal fight law. You're going to win, but how's that person going to survive in the interim? And I've had several instances where the employees buckled and took the pittance. I advised them to go to court and say that they were under duress, but so far nobody has actually taken that advice from me. Because there was one instance, sir, where a Queen's Counsel was instructed by his client to go and prepare a release because we had settled on $230,000 for an employee that was unfairly dismissed. The employer said, yes, be wrong, we can pay the money. And asked their lawyer to prepare a release. No, never you would not do that. You're not that unethical. This lawyer, when he got the instructions, they told me, well, can't speak to the lawyer. I called the lawyer and said, Caswell, I can't let my clients pay this kind of money, man. But this fellow just refinancing mortgage. He can't survive. He can take $90,000, or he going before trial and take 4 years. Fellow took the $90,000 because he cannot wait 4 years. One of the things that I am suggesting should happen is that the government should pass, if they want to do an amendment, should say you can't pay less than what is provided for in the 5th schedule. You can pay more. The 5th schedule is the section that says how much you will pay, 2.5 weeks for 10 years, or 3 weeks for more than 10, or 3.5 for more than 20. But because of the unequal position of the employer and the employee, and the fellow just lost his job. So there's nothing for him to hold on to, because when you go to national insurance to get unemployment benefits, there's another problem. National insurance seems to think that, the officers of national insurance seem to think that the money is theirs, and always finding some reason to deny persons up to 6 weeks of their benefits. I will use an anecdote. I had a situation where this person got dismissed from his workplace, and he went to national insurance, and they decided they're going to take 3 weeks because he lost his job through his own misconduct. That wasn't the case, but the officer at the national insurance determined that they will take it. So we appealed. When the case came up at the appeal, the chairman asked me to address, I said, Chairman, sir, I don't want to waste time. Let us call the officer who made this decision. She was outside waiting. And we asked her, why did you cut this man's benefit? You know what she said? She says, I was entitled to take away 6 weeks. So I divided in 2 and I take 3. No reason what, that's the reason she gave. Simply because they have the power to take away the benefits. So a fellow now who has lost his job, the employer is not paying the compensation that is due, and the employer knows is due, and the National Insurance Department routinely finds reason to stop people from getting their benefits. And then again, of course, I have to go and fight cases like that, and I do it pro bono, by the way, because I think it is unfair for a fellow to lose his benefits and then, through no fault of his, and then go up here to do it too. So I do that as a community service. I don't want everybody coming though, but that is the case. Right? So I'm saying, sir, the act should be amended to say employers must pay what is in the schedule or more. They can't pay less. And I think that would be a good thing. You know, and we wouldn't have these unscrupulous lawyers doing the dirty on poor, defenseless workers. The next thing I want to talk about, sir, is employers who dismiss workers because they have an expatriate that they want to give the job to, or they have an expatriate that they want to think. No, that we're not talking about your case. I had a case at a South Coast hotel where one of the conditions of employment of the expatriate general manager was that they would train a local person to be understudy, that a person could take over. They got the 3-year contract. And as 3 years was coming up, they fired the understudy. And then they will go to immigration and say, the understudy is no longer here, we need another 3 years. Trinidadian-owned hotel on the South Coast. I'm not telling you on this mic live, because he's not here to defend himself, and I don't do that. But we need to fix things like this. We also have workers who get these work permits coming to Barbados. And to my certain knowledge, the employers pay them something like $10,000 a month deposited in the US. And they report to the Barbados authorities that the persons are getting $3,000 Barbados or $4,000 Barbados. And they pay taxes on that amount and cheat the government with these work permit scams. And you won't believe some of these people sat on the central bank board and all kind of stuff and doing this thing. You do your homework. We have local employers who, seeing the nastiness that transpire with the foreign ones, they decide they're going to get in on the act. We have one business in Barbados who always boasts that they have 600 plus workers. They don't say that they treat them like dirt and that 35 of them are permanent, all the rest are part-time. And that also when these workers sign in on mornings, they can't leave until the end of the day. They say, and they have it in their handbook, that you must take your lunch on the compound and you can't leave. Just recently, I had to defend a young lady who left during her lunch hour when she was dismissed for it. This restaurant. And people even like them for doing this nastiness to our workers in this country. Workers, and this thing is, these people are not professionals, and they have to work for somebody else, so they have to grin and bear the nastiness that happens in the workplace. When they leave, you imagine you can't leave for lunch. They said, we give you lunch, so you can't leave. And matter of fact, they only give them half hour for lunch, which is contrary to the shops act. And restaurants are under the shops act. And they give them, and they can't leave, you know. And the law is that after 4.5 hours, you must give the person an hour for lunch. And they don't give them, and they don't care. because they know who they can speak to at the Labor Department to get things to go away. And the thing is, sir, when an employee goes to the Labor Department to make his case to the labor officer, the last administration passed an amendment to the Employment Rights Act, or passed some amendments to the Employment Rights Act, to say that lawyers cannot file cases on behalf of workers. Well, I don't mind that, because when the lawyers can't do it, I can do it, they can, you know how it is with me. But it is unfair. You cannot tell people who to choose, right? They can choose me, or they can choose Senator Moore, or people that are in UPW. But if a lawyer thinks the chief labor officer is not entertaining you because, and a lot of people do not know that this amendment exists, but the chief labor officer certainly does. And what they did to sneak this amendment, sir, and please don't tell me I'm attributing improper motives to people, they sneak it in. They amended, they put it in the Holidays Repair Act. They amended, the last administration, they amended the Employment Rights Act by putting the amendments in their schedule to the Holidays Repair Act. So most people don't know that it exists. So it says here now the complaint used to mean one thing. Now it says complaint means a complaint made to the tribunal by an employee, by way of the chief labor officer, or by a trade union, as the case may be. You know why that happens, sir? Not causing me. Because some employers went to the Labor Department, to the minister, to everybody else, and they complained that they're bringing lawyers in there. Mind you, they have lawyers, you know. But they don't want the employee to have a lawyer. So they prevailed upon the last administration. You're talking about things that they did in shame, this is one of them. They prevailed upon the last administration to exclude lawyers from filing. And even though, sir, they said that a trade unionist can file on behalf of the workers, the new Section 42 that was amended says, Section 42(1), where an employee believes that there is a dispute or issue concerning an infringement of any right or benefit conferred on him by this Act, or under the provisions of any other enactment relating to dealing with employment standards or other employment rights, he may make a complaint in writing to the chief labor officer. When I make a complaint to the chief labor officer, and you would expect that the matter going forward, the chief labor officer, no, the person going to come in and make the complaint themselves. This is happening in Barbados today. You imagine, the law says trade unionists, and I'm one, can make complaints on behalf of their workers. I write and I set out my complaint, I ground it in the law, and I show them where the complaint is, and the chief labor officer ignores that and says he wants the person to come in. And then that person now has to go, or failing that, there's no conciliation, you know. Man get too big for his boots. He even ignored the legislation. He even goes as far as to give legal opinions and saying his opinion. He can't got the legal opinion right. First of all, he's not a lawyer, and then legal opinions must come from the Solicitor General in the public service. But no, he decides, well, this is an interpretation of the law, and I'm not sending it to the tribunal. He has done that to me on one occasion, but we're going to court on that. The relevant section, Section 44, says, where the chief labor officer is unable within 42 days of the making of a complaint, except in extenuating circumstances, to effect a settlement of the complaint under Section 43, he shall make a report to that effect to the tribunal. It doesn't say if he feels like, or he might do it. If he, no, it says he shall make a report to the tribunal. The man refuses to make reports because his interpretation of the law might not accord with what he believes one of the other parties is saying. So he rules against it. Yeah. So while workers have rights in this country, they are being frustrated. One, they're frustrated by the manpower shortage at the tribunal. Three panels and one secretary, one transcription clerk. As it will be, there are not two people I'm talking about. Secretary and transcription clerk is one person. There's one person. So you cannot get cases heard. And when the cases get heard, or they're being heard, we have all these kind of delaying tactics. So you said we really need someone like Senator around there who is a dispatch things fast. But you're no longer on these tribunals, are you? You know, you people make a mistake here. Mr. Chair, the government made a mistake by removing or not reappointing persons like Senator Tate to the tribunal. They used to get work done. She's at the Seventh Payments Tribunal. I don't know. I don't know, but we used to get good work out of her. No, they got rid of her. Sir?
Mr. President, the honourable member is, I'm sorry to interrupt him, he seems to be all over the place, but certainly as it, in terms of the tribunals of the NIS, the tribunal, certainly the servants one, has not been reappointed.
I'm aware of that.
So clearly, Mr. President, he's misleading this honourable chamber.
Mr. Chairman, Mr. President, that is the leader of government business just admitted severe negligence on the part of the government, sir. The government was elected the 24th of May, 2018. This is now January 2019. And they have not reappointed tribunals, and people are waiting for them. And he had the gall to stand up in here and tell the country so. It's something that the government should be ashamed about. You know? The one that can't get my cases heard, the tribunals are reappointed.
As I recall, the honourable on a point of order said that I can't remember, it was in English. It was in English. They get rid of her, and they did the worst thing. He was extremely reckless in that remark, Mr. President.
Mr. President, on a point of clarification, while I appreciate the compliments from Senator Franklin, for the record, I wasn't gotten rid of. My term came to an end. For purposes of clarification, my term came to an end, and as Senator Walker correctly said, as far as I am concerned and my knowledge takes me, those tribunals have not been reconstituted as yet. So while he is going on and speaking of my virtues, perhaps he could just stay on point, which is, for the record, an amendment dealing with oaths. I'm not sure how we get to be doing all of what he's talking about, Mr. President. Just while I'm on my feet, I'm seeking a little clarity on the amendment before me, unless I'm missing something. We're dealing with... As much obliged, Mr. President, just was wondering about Mr. Franklin, Senator Franklin, where he's going.
Sir, as I wanted to make this thing short, but people don't let me. You know, you know. I know they have not been reappointed, and I know that the time ran out. But when the times ran out and you have cases pending, what happens? They put a new tribunal in place, they're going to start all over again, and people are waiting years to get a decision. It is unfair. That's what I'm telling you. We have, same thing with the Employment Rights Tribunal. Right now, I have a case before the tribunal that was heard by a panel that consists of the former chairman and 2 other people. All we were waiting for is for the decision to be handed down. All the evidence was in, and the government changed, and they did not make any provision for the old panels to continue and to give their decisions. I don't know what is going to happen there, because this young lady, she's been in so long, like I said, this old lady, because she was dismissed in 2013, had a case heard 2017, and the tribunal took a while before it delivered its decision. And the decision had not been delivered before in this case, got rid of the chairman. I think it's unfortunate, and I think that government need to do something about the Employment Rights Tribunal, and my concern is that they are not taking the Employment Rights Tribunal as seriously as they should. You know, these are people who need. I understand you, Brother Walker, Senator Walker, but I have to make representation on behalf of the people who are suffering. People who are suffering in this country because of government's inaction. Right? It is unfair to be dismissed, and the law says you have 42 days for the chief labor officer. The chief labor officer, years go on and nothing happens, and nobody is doing anything about it. Yeah. One of the last things I want to talk about, sir, is when I go before the tribunals, one of the things employers do is to say, oh, that person was not an employee. They were on contract of service, so that they can dismiss people and give them nothing. Mind you, they're not paying the national insurance either, because they claim that they're private contractors. You got a private contractor maid. I had one of those already. You got a maid working, you're cooking your food, you want to she's a private contractor. Yeah, a maid. Take care of your children, cook your food, clean your house, and you tell me she's a private contractor, and she goes there from 7 o'clock in the morning and finish work, then you come home after 4:30, and then you make sure you're going to catch the bus, and then you're going to tell me when she's a private contractor. But a lot of people in this country are doing that. And let me tell you something. So far, as I remember, the only authority in Barbados to determine if a person is a private contractor or is working under contract of service or contract for service is the National Insurance Board. Under the National Insurance and Social Security Determinations of Claims and Questions Regulations, the board makes that decision. But we also had government departments doing it, you know. Under the last administration, we had the Ministry of Drainage or whatever, have people working at 8:30 to 4:30 in their department and calling them private contracts, not paying national insurance for them. You know? So it isn't, but when government sets bad example, other people will catch on, you know. And I'm not talking about, you remember, I'm talking about the last administration. This is what they did to disadvantage workers who work at 8 to 4 and give them vacation too, you know. And provide them with the desk and everything they need, and you can tell me they're private contractors. And the government. So when private employers do it, you know, it puts pressure on the workers' representatives to fight issues like this. I want to, finally, sir, and I'm going to be final. We have a system here where the government goes out and invite people to come to this country to provide employment. And these people bring some very bad employment practices, and they treat the workers very badly. Matter of fact, they treat me very badly. I go to Belches in St. Thomas to represent some person, and the fellow say he ain't talking to me, turn it back in the chair. Pardon, sir? I go to Belches. I'm not saying who. I'm saying I went to Belches because they can't call names of people up there here. So I said I went to Belches in St. Thomas to represent workers. Yeah. And the management said in a meeting says you can only sit down, but you cannot talk in here. I said, what are you talking about? I talk enough. I gotta talk. I am a representative. I'm not an observer. He said, well, all right, talk then, and turned it back on me. Man, this, and then the case finished, and then the guy is now deemed to be redundant. Matter before the Employment Rights Tribunal, 8 months gone, 9 months gone, and those 42 days have not passed for the Chief Labor Officer to deal with that matter. There's some bad practices, though we have others in the harbor, industrial park, and elsewhere, who insist that workers come to work at a particular time, and they sit down there and they get a bathroom break, and if they go for a second one, And if they want toilet paper, they go to management and buy them some toilet paper. In Barbados today, this is a company down in the Harbor Industrial Park that I had to go and deal with. And if some person is already in the bathroom, even though they have 4 stalls, they say, and you want to go to the bathroom, you have to type in a chat. Emergency. This is happening in Barbados today, sir. What we need to do in this country, sir, is to have legislation that sets out terms and conditions of employment of workers. If you're going to employ people in Barbados, these are the terms. You can have other terms, but these are standard terms that must apply to anybody employed in Barbados, except you're working for an embassy. Because if you're working for the embassy, you're working for the country that thing. But people import some very bad employment practices, and then when the workers stand up, they fire them. They refuse to come to the department when the Chief Labor Officer invites them. Even though he has powers to force them to come, they don't come, he don't say nothing, you know. And they're treating our people in this country very badly. It is unfortunate, sir. I want to get into a wider debate on employment rights, but since this is only dealing with the amendment to the to introduce an oath into the legislation, I will not delve too far down to say anything more, but I don't know what is this to support. You know, the people were having cases and all along, and they decide, well, they're going to have an oath. But if you want to have an oath, you have an oath. It doesn't really bother me one way or the other. You know, it is not substantive enough for me to deal with when I have so many pressing issues under the same employment rights legislation, you know, that I can talk about. But as I said, Since I'm not here to deal with them today, I will leave them out for another time. I'm much obliged to you, sir.
Thank you, Mr. President. This bill would amend the Employment Rights Act 2012 to provide for the requirement of an oath or affirmation of office to be taken by a person who is appointed to the Employment Rights Tribunal. I wish to start by commending Senator McConney for her opening submission. Because that opening submission, which went far wider than the amendment before us, suggests to this chamber, and indeed suggests to us all, exactly why we shouldn't be in here at this time debating the amendment before us. Because in that submission, if the submission had to deal with the 10 words of the amendment before us, then there will be nothing really further to input. But her submission spoke very widely about the Employment Rights Act being at the base of the employment relationship. It spoke about not only the things that we should do, but the way in which we should do things in the interest of preserving a positive employment relationship. Where perhaps I digress, or differ to her in her perspective, is that the reference was to the Employment Rights Act, this particular amendment to the Employment Rights Act, as a progressive step. There's nothing progressive about it. It is simple, yes. Harmless, yes. Does no injury to the worker or to the employment relationship, but neither does it add any distinctive benefit or improvement on what currently exists. And this even after 6 years of its proclamation, or almost 6 years of its proclamation, and within 6 months, we could have been citing areas where amendments were needed. And not only publicly speaking of these, but writing to the Ministry of Labor, asking for further consultation, because immediately or within short time of the act being proclaimed, there were recognized difficulties. Indeed, I would say that before the act was proclaimed, we recognized that it was not a perfect piece of legislation. But as Senator Franklin said, the act took 10 years, and what he called the gestation period, took over 10 years for us to get that imperfect piece of legislation in place, against an understanding, therefore, that having taken so long, it was at least important to start with something. But along the way, we recognized that there would have been areas that will have to be tidied up. So my contribution today is not intended to be a criticism of the proposed amendment in itself, which, as I said, is to provide for the requirement of an oath by a person to be appointed to an employment rights tribunal. But rather, it is a criticism of the piecemeal approach that is being adopted to introduce a very cosmetic change when there are far more fundamental changes that are required to the piece of legislation, and where these proposals have been before the Ministry of Labor for the last 5 years. So where I differ with Senator Franklin is that he's saying that he's not blaming the government. This government. But I blame this government. And the reason that I blame this government is this government has shown us that it understands urgency. It understands the need for speed. It understands the need to deal with issues that have to be addressed for the reasons that they say are important enough for these issues to be addressed, but a piece of legislation which speaks to the core of the employment relationship, which speaks to the heart of the people in the employment relationship. Amendments which would speak to giving protection, enhancing the rights of a piece of legislation that is supposed to provide for rights to employees. There's no rush. So we could deal with everything else under the sun. We took a whole day today looking at another piece of legislation, important, of course. But at this hour of the evening, we squeeze in a discussion because really, if you look at the amendment as it is presented before us, really nothing to look at. So, an Employment Rights Act and an Employment Rights Tribunal taking an oath. The tribunal has been in place since the 2nd of August. And another 3 days, the tribunal would have been in place for 6 months. Not one case has been heard. I'm saying comrade because we agree this evening. Comrade Franklin is saying 400. He probably has more details, but I can safely say that well in excess of 300 cases still remain unheard before the tribunal. We have not heard about what facilities are being put in place to ensure that the Employment Rights Tribunal is going to be better resourced. We hear references to it. No discussion of what these facilities are. So we haven't heard how the backlog is going to be addressed. And the backlog not only relates to the fact that the tribunal has one secretary, it also has one transcription machine. The reasons that they have cited for the inability to hear cases also, and this is by the former Minister of Labor, also related to the fact that they didn't have a place to host meetings. Now, the Barbados Workers Union offered, and we offered specifically a facility for those cases that didn't relate to the Barbados Workers Union, because you won't want anybody feel we're using your building, so we gotta find in favor of the case you're presenting. But these are the real challenges, and I don't know, we are going to be getting into estimates debate very shortly, and I look forward very eagerly to seeing the Ministry of Labor make provision, necessary provision for the resources, not only the manpower resources, but the resources generally to facilitate the process. So we also haven't heard about what will be done to ensure that the Chief Labor Officer will exercise the powers of his office and not palm off matters to the Employment Rights Tribunal because less effort is required of him in doing so. What we got from the Ministry of Labor only about 2 months ago are some recommendations from the Employment Tribunal that has been appointed since the 2nd of August, asking for comment. We have a number of amendments that have gone through discussion, commitment that these will be sent to, what is it called? CPC, sent to CPC. Nothing has come back, but what we have are further amendments about 3 or 4 of them submitted for comment. I know this, an amendment, perhaps to make it look to people like me, like, well, you ain't had an oath, so we can't really do anything meaningful to maybe to justify why for 6 months you're there, and nothing else has been done. You know, these are asking for there to be an oath taken. So the tribunal that was functioning for the last 4 years or so wasn't seriously addressing cases. The reason, maybe the suggestion that would go out to the public, is that the reason that only 10 to 13 cases or so have been heard is because tribunal members didn't take an oath. But for people in the system who understand and who know all the challenges that I spoke of previously, we know it doesn't relate to that. Maybe, Monique, you could say, Senator Tate, you could say in a few minutes what you know it relates to. I am not going to repeat any comment from you or anyone that it is stalling or to give greater importance to something that it deserves. I will not repeat those comments. There's no mention of how the resources of the Labor Department will be strengthened to reduce the number of nuisance cases which are being sent. And Senator Franklin spoke of a number of his cases. So there's no mention of how those companies that cost you more, even although they advertise that they cost you less, no reasons being put forward on how a chief labor officer is going to get them to respond, to come before him and answer charges of denying workers their rights to freedom of association. No mention of how that office is going to be strengthened so that cases, similar cases against Intertech and other companies, won't have to be escalated to the tribunal only to be sent back down because they have not gone through the conciliation process. No mention of these things, but we asking for oath. No indication of when cases will stop being stalled at the level of the Labor Department because employers won't accept that the legislation provides for the trade union to raise issues on behalf of its members. And yes, Senator Franklin is right, in part because they tack on an amendment in a Schedule 2 of the Holidays with Pay Act. And some of the officers that have to deal with these cases in conciliation either forget that the amendments have been made or don't care to recognize that the amendments have been made because it's easier to let these cases become lost in a system of 300 or 400 other cases that are yet to be heard. Not a single word on how we can correct the injustice where a stipulated probation does not allow a worker with less than 1 year's employment to claim unfair dismissal. An employee who has 11 months and has been unfaired in the system has no rights under this piece of legislation. But we favoring an amendment for an oath. No proposal to address the issue of some employers forcing workers to declare themselves as being self-employed, only so that the employer may avoid the social charges of having staff. And I understand that this might be a ticklish one for the government too, because in the recent retrenchment exercise, that has been a bone of contention. We recognize that jobs are still necessary. We recognize that functions are still required within these state-owned enterprises. But what we can do is keep them on staff so we can sever them And then we could probably bring them back to provide for us services under an arrangement known as contracts for service rather than contracts of service. Perhaps, I won't be presumptuous, but one can conclude that maybe that's why there's no haste. Maybe there's some conscience residing in the Ministry of Labor that if we are committing these same acts, we can go there and amend them, and we certainly can defend a position. The real issues denying justice to many do not relate to the fact that members of the tribunal haven't taken an oath. They have largely to do with the fact that simple matters of principle are not being resolved. At present, 2 cases referred from the Chief Labor Officer to the Employment Rights Tribunal must restart at the level of the tribunal, notwithstanding evidence and statements which were submitted to the Labor Department. So on top of the fact that we have all these issues that are before the tribunal, even where those issues were before the Labor Department for conciliation, nothing of what was discussed at conciliation can inform the decision in those cases, because everything has to start over from scratch. Parties, therefore, could change statements and submissions. When a matter has escalated, you go to the Chief Labor Officer and you get a feel for where you may or may not win an argument, and you could twist and turn your submission, because when it gets to the Employment Rights Tribunal, perhaps after 3 years, perhaps after 4 years, you now have to start all over again, and that's why the person would have accepted $90,000. Because is it really worth it? In 2015, the public's comments were being sought on proposed changes to be made to the Employment Rights Act. Since 2016, comments were submitted to the Ministry of Labor from employers and workers' representatives. This process of review remains seriously protracted and is yet to be concluded. No follow-up meetings have been had within the last 14 months to look at how we are going to close in on agreement to the amendments that have been under discussion. But as I mentioned, in November, by correspondence dated November 12th, further comments were solicited, and based on questions and proposed changes by the tribunal appointed on the 2nd of August, and relevant comments by the CLO on their submissions and questions. I have a problem, and it is not with the words before us in the amendment, therefore. It relates to the entirety of my submission, especially when one considers that in the prevailing climate of uncertainty, government's commitment to strengthening labor would have been more evident if, even in a piecemeal approach, this amendment could have been accompanied by other amendments of substance that reach down to offering protection to workers. So as I said, we've rushed through a number of things, but for an amendment that speaks to people. As I was sitting here earlier following the debates with the other amendments that were before us, I received some correspondence. Correspondence that's being written carrying today's date, informing the General Secretary of the Barbados Workers Union that a state-owned enterprise has to undergo further changes that will see 17 people being retrenched tomorrow. Today for tomorrow. Earlier this week, on Monday the 28th, I'm aware that the General Secretary of the Barbados Workers Union had to write in response to another state-owned enterprise who wrote by letter dated January the 24th to indicate we making changes that can commence Friday on Monday, February the 4th, over at the BTMI and the BTPA. So where government, this government that Senator Franklin refuses to blame, where this government is breaking the very provisions of the Employment Rights Act, maybe I shouldn't be surprised that this government would only see it necessary to make somebody feel big up going before the Governor General to take an oath, as opposed to dealing with the issues that speaks to the notice that is required when you're having these discussions. Yes, everybody knows that the public sector is into a retrenchment program, but because it comes from on high, it doesn't mean that when we come down to discussing, or should be discussing, that all of a sudden we disregard our principles. The very people that are being asked to implement these decisions ought to be able to say, no, it is wrong. But that's the problem with our system. So Senator McConney, when you spoke about not only what we do, but how we do it, I was intrigued, but I was also embarrassed for you, because you are speaking about what to do and how to do when your very actions suggest that you don't care about what to do or how to do. When we come to the amendments, if we come to the amendments that have been before the Ministry of Labor for the last 5 years, there will be a lot more that can be said. But as it relates to this amendment, to agree or not to agree, this ain't make no sense to me or the workers out there that depend on representation like mine. Mr. President, I rest. I don't have anything else to say on this.
Senator Boyce.
Thank you, Mr. President. Senator Moore has me a bit rattled. I had prepared for my fellow senators a lovely discourse on the history of oaths in Barbados and the legal rationale and merit, or at least discussion, as to why the amendment sought, from a legal perspective, and to engage in some debate as to why we find ourselves here from a purely legal perspective, actually to debate what was tabled in the order paper. Now, there are some attendant issues, Mr. President, which have arisen, and I plan to be very brief. Not as brief as, not brief in the terms of Senator Franklin, but real brief in terms of some notes which I think will benefit fellow members, and also to allow the joining of issues with regard to the points both eloquently made by Senator Moore and to some extent by Senator Franklin. Mr. President, you will see before you in the bill the proposed amendment to have the members of the tribunal swear these oaths. And of course, it did prompt a question as to why this would be necessary. And that question then led to some investigation as to why we have oaths and why we deem it necessary for certain matters. Generally, as you would be aware, Mr. President, we have the Promissory Oaths Act at Cap 28 of the laws of Barbados, which deals with the general form of oaths to be administered as determined by Her Excellency or as required by the Constitution. But it does specifically contemplate that certain legislation would require that certain officers tasked with certain important matters be required to take an oath of their office. Now, historically, and in this regard, I will not take credit. I have to let it be noted that I was provided with great assistance by Ms. Enid Campbell in her text, Oath and Affirmations of Public Office. But historically, the concept of an oath of judicial office or an oath of service, even the oath similar to what all of us would have taken before we sat in this honorable house, derived under the system that we follow, the Westminster system, as a way of ensuring that persons who served were persons who were loyal to the throne or indeed to the Church of England. So what you found was that the early oaths required that you have to have a form which condemned any doctrine that sought to give credence to what came out of Rome. And you had to declare that no foreign prince, person, prelate ought to have any power, jurisdiction, superiority, preeminence, or authority within the realm of England. I'm hearing whispers of good oath. However, what was found was that the making of the oath soon became a condition which was somewhat rigorous and was utilized as a form to exclude certain persons. One of the forms of oaths that was utilized was that you could not believe in transubstantiation, which means Senator Walcott would be unable to serve in his capacity, because as a Catholic like we have certain beliefs. And these were the restrictions that were utilized, along with members of other faiths, to restrict them from serving. In other words, if you wish to serve in this capacity, the oath would force you to belie certain of your beliefs. So it was a very interesting legal journey that I found myself on, and I thought I would subject my fellow senators and the public of Barbados to the same, because we're going to get to the point. What was found, though, was that in order to ensure some fairness with regard to the wording, a form of oath that was less onerous was required, and it was accepted throughout the realm. And we, of course, would have received our own version by settlement and as encapsulated by the legislation which I just mentioned. But what came out of this examination and from some legal queries and critics was what would happen in instances where, like in this case, there was not a previous requirement for an oath and now you're introducing one. What would happen to the previous decisions that were given, which were made when these members of the tribunal were without oath, and what would be their effect? And the answer for that is quite simple. At the time the decision was made, there was no requirement under statute for there to be an oath. So those decisions will still be valid. And even if there was a requirement for there to be an oath, and there was no oath taken, the legal principle of de facto de jure action would mean that once you had submitted to the tribunal's jurisdiction, you accepted the decision that you were going to get. So, Mr. President, it was a quite enjoyable journey from a legal perspective to see where the framing and the conceptualization and the rationalization of the need for the oath arose. And given the importance of the members of the tribunal and the importance of the labor movement, there is perhaps a sound rationale for the legal requirement that the oath be sworn going forward. In terms of the other matters raised by Senator Franklin, by Senator McConney, and by Senator Moore, very passionate. This is the most passionate I've heard from Senator Moore in our short history together. But there was one misconception with regard to workers in Barbados, in that workers in Barbados who have been employed for less than 12 months correctly do not have the benefit of the Employment Rights Act. But under the common law, there is still the protection, very little protection that it provides with regard to the wrongful dismissal. And I say this to say that the Barbadian worker, I believe, and the Barbadian employee has a number of resources with regard to protection in circumstances where they are finding themselves at a disadvantage.
Point of order, sir.
Let me hear what his
I hate to interrupt Senator Boyce. He was going so good, but Senator Moore is absolutely right. In Barbados, under Section 27 of the Employment Rights Act, it says an employee has the right not to be unfairly dismissed by his employer. That's Section 27(1). But then it says subsection 1 does not apply to the dismissal of an employee unless he has been continuously employed for a period of not less than 1 year, ending with the effective date of termination.
What is the point, sir?
So the point is that he misled himself and the House. And what happens here, sir, is that even under the other common law he's speaking about and everything else, if you are seeking wrongful dismissal, they require you to be employed
I do not
for 2 years.
accept that, Your Honor, on any valid point.
Like you said it.
Thank you, Mr. President. Again, I am guided, Mr. President. My friend, Senator Franklin, is stepping a little bit out of his depth, but the categories available to the Barbadian employee, you have the remedies under the common law, which is wrongful dismissal. You have the remedies under the Severance Act, which is in cases of redundancy, and you have the remedies under the ERA, which provides for unfair dismissal. And the establishment of the ERA widened the statutory basis of relief and was quite innovative in terms of the legislation, in which was sought to provide protection for that area of law in which workers could be disadvantaged, in which an employer can say, I am terminating your employment by giving you what I believe to be reasonable notice. So I'm going to give you, quote unquote, a piece of change, which was calculated by your length of service, by what you did, and a number of other factors, and that would allow you to terminate the employment. What the ERA provided was that in such situations, you had to have fairness in your determination with regard to that employee, and there had to be a process that was followed. Also, the ERA and the Employment Rights Tribunal has been tasked to deal with the issues with regard to sexual harassment. So we find that the Barbadian employee, I would say, is well protected with regard to the law, both common law and statute. However, to the point made by Senator Moore, and to some extent, very gingerly by Senator Franklin, even if you have the protection in terms of legislation, unless the resources are provided, the implementation is the issue. So let's look at what the Employment Rights Tribunal is being tasked to do. The Employment Rights Tribunal is being tasked to deal with cases relating to unfair dismissal. Now, unfair dismissal is extremely wide. Unfair dismissal is a legislative remedy in which you examine the process that was followed by which the employee was terminated. It could also, in some extent, extend to redundancies, whether the redundancy process that was followed was fair or unfair. And it requires an examination and no discredit at all to Senator Tate, but the evidence that is required to be examined in a case of unfair dismissal sometimes is required to be more than the evidence required in a case of redundancy, which is a determination under the sections of the Severance Act to see whether or not the requirements for the job to continue still exist. In a case of unfair dismissal, Senator Franklin, the tribunal members are being tasked with examining all the facts surrounding the termination and to make an assessment as to whether the termination was done fairly. This is a question of law, Senator Franklin. You need to be guided and to understand, Mr. President, and to understand the difference in the parameters. So, Mr. President, what happens is that we have a situation where the employment right tribunal officers or the members of the tribunal, sir, are being tasked with a extremely complex exercise in terms of reviewing the facts leading up to the determination and coming to the findings. As we have heard from my fellow senators, they have one secretary/transcriptionist. So that means only one tribunal can sit at any time. There are between 300 to 350 cases currently in the system. At the rate that they're going, we can see where this will lead to difficulty. At this point, we have to join in pleading with the government, and we understand the pains of the government with the lack of resources available. But if some allocation could be considered to speed up this process, we really believe it should be prioritized. Now, what happens next, sir? Mr. President, the issue of housing. The Employment Rights Tribunal finds itself at what we call the barrack building. It uses the conference room facilities, which means that they have to schedule and book and try to get a room in which to hear the matters. You can imagine how that would lead to delay. When we compare that to the relative luxury of the NIS tribunals, which have, I believe, 3 rooms on the top floor or the third floor of the NIS building, very comfortable, and they're always running. So the machinery was right there. I'm not saying to cannibalize what is there, but certainly a page could be taken from that book with regard to establishment as well as to implementation. And I believe there is a secretariat, there were a pool of secretaries and very skilled persons. There was a secretariat who were able to provide support to the tribunal members of the severance tribunal. The long story short, Mr. President, is that resources are required to allow the tribunal to move forward. And I think that the government will take its licks fairly, but knowing the government, they will respond and will provide the adequate resources to get the engines moving again. Now, there are 2 further concerns I would like to raise, Mr. President, and I assume, and it derives specifically from what Senator Franklin and Senator Moore raised in relation to the workers. The existing legislation does not provide for costs to be awarded, and I believe this is something that Senator Moore, you will need to have your advisors speak to the government's position on with regard to costs being awarded to tribunal matters which are started, which are commenced flippantly, or which are dragged on by dilatory efforts by persons seeking to frustrate the system. But one of the major problems right now, Mr. President, which I believe is facing the tribunal, is the fact that the 5th schedule provides that when in making an award, there is a segment in which the tribunal can make such award as it thinks fit. And you would have heard Senator Franklin speak to an award of 6 figures and quite gloriously speak to what could have been or was not gotten or what was awarded. And in examining the decisions coming out of the tribunal, Mr. President, you are seeing that there is a variation which goes perhaps beyond the discretion which is currently in the hands of the tribunal. The reason is this. In the case of QT Lynch and the NCC, sir, the tribunal awarded the period of 52 weeks as some other amount. This is within the discretion, Mr. President, and where the tribunal has a discretion to award an amount such as the tribunal thinks fit, which the employee might reasonably be expected to have had but for the dismissal. And the issue is this: because of the attendant delays in hearing the matters, when the award finally comes, and we have this backlog of 300 and 350 cases, and with there being no certainty of how that award is to be quantified, the state may find itself in a very desperate position in which awards are being made which cannot be satisfied. Or there needs to be some clarity with regard to the range of the awards which are to be given and some guidance from a legislative perspective. And the reason I say that is that when we examine 3 of the recent decisions, we will see the variety of the time periods being put forward. In the case of QT Lynch versus the NCC, sir, what was determined to be reasonable was 12 months in that case. And this was aside and separate, of course, from the award calculated pursuant to the regular amount of time working. This is what the tribunal said: you took X amount of time to get this decision, you should get Y amount of money. In this instance, sir, 12 months was given. In the case of Wendell's story, sir, the period of 6 months was given. And in the case of Orlando Harris, the period of 27 months was given. So you have a situation, sir, where employers and or the state is finding themselves, and it's a correction, employers are finding themselves in a position where, due to a lack of a mechanism of the tribunals being moved forward, there is a risk of decisions being given, of substantive decisions being given due to delay. So this matter needs to be addressed with some urgency, and there needs to be some clarity given by either the courts, which is unlikely to reach there before, or the legislation with regard to the nature and the quantum of these awards. Long story short, Mr. President, there is legal basis for the requirement of the oath. There is legal basis for it, and the work of the Employment Rights Tribunal is significant and has a great benefit for this country. But in order for that work to be achieved and for the results that the workers of Barbados need, it needs to be properly funded, staffed, and resourced. Those are my contributions, sir.
Thank you. Senator Goodrich.
Thank you, Mr. President. Mr. President, the Employment Rights Tribunal has the authority to adjudicate on matters which involve an employee's dismissal or discharge from duty by his employer. And in law, we call that the unfair dismissal. But, Mr. President, the same case on the same facts can also be tried in any magistrate's court in this island for wrongful dismissal. No, sir, let me say up front that my main concern with this amendment is giving the appearance of an attempt to clothe the tribunal with all of the similarities of a court. I have that concern. The tribunal, to my mind, is a place for the small man. And let us not frighten him by making it appear to be something other than that. Employees do not really like the formalities of a court. I can tell you that from experience. In fact, you could almost say people generally do not like to go into court. Employees prefer to go to a well-oiled and a proper working tribunal. Because at the tribunal, exactly, they're not those legal formalities. And there is not that reverential fear, sir, that awe of a court. Where you kiss the Bible, yes, where you believe that you have to speak in a particular way, and if you interrupt, you may be charged for contempt of court. Employees do not like that kind of style. The hearsay rule, for instance, in the tribunal is not slavishly followed like it would be in a court of law. The point I'm making is this, sir, that employees should be far more comfortable before a tribunal than before a court. They should be made to feel at home. So my point this evening is, let us not clothe the tribunal with all the trappings of an appeal court or a high court. In England, sir, employees hardly step into court in dismissal matters. They are in and out of the tribunal in about half an hour. Their case is over. The thing about the tribunal, too, is that you can be represented at the tribunal by a person of your choice in England. You do not have to be called to the bar to go into a tribunal to represent a worker. Employees hardly ever take a lawyer into the tribunal. Very often it is just the employer and the employee. Sometimes you do get the trade union representing the employee and an employer association representing the employer. And in England, those cases before the tribunal, they're all finished in less than a day. Some days they do 3 and 4 in the same building. Employer and employee will go into the tribunal, they will state their case, and in a flash, they're out. When our Employment Rights Tribunal was set up, that was what we intended to. I had a big say in it. That is what we intended to. Today, I have to admit, ours is not a model tribunal. We have a situation, sir, where a tribunal which was designed to speed up matters is operating like molasses going over Thornbury Hill.
Very slow.
Real slow. I would like to be able to say that in a better way, sir, but I can't.
We all understand that.
Real slow. You will have a lawyer who would have about 10 cases before the tribunal, never being called down to say, we're ready for you, we're ready for you. Not a date to appear before the tribunal. And sometimes those employees will be putting all the blame and the pressure on the lawyer. And some of them may even be calling back for the files from the lawyer.
That's not really fault is.
This is a sorry and a sad state of affairs. So the overarching point which I'm making is, let us not appear to be tinkering and mending those household things in a tribunal simply because the tribunal does not conform to the judicial requirements of a court. We may end up making the tribunal a perfect court if we continue to do this, and it would defeat the whole purpose of having a tribunal in the first place. I agree somewhat with Senator Moore when she said that this particular amendment does no harm. It does no good. It does no harm. And I know the person who is now at the helm of the tribunal. And I know that you need someone with some kind of jurisprudence to be in that position. But even that, being a retired judge, has its implications.
Limitations.
Has its implications. The features of a court. Now, Mr. President, the next point I want to make is this. I enjoyed the contributions of Senator Franklin and Senator Moore, the trade unionists in this chamber. And I am going to urge them to represent the workers in Barbados, as we would say, represent them to the hill.
Fully and fairly.
They need good representation in these difficult times. Represent them. Anytime you consider that they're being unfair, I urge you to speak up. At the same time, too, I will urge you to look around the world, and you will see that every single country that has had a massive financial and economic problem has had to resort to layoffs. And you know a country that had real economic problems, real economic problems, a country called Barbados. And if this government had not wrestled that monster to the ground, there would have been a crisis of seismic proportions in this island. We have averted that crisis so far. And in so doing, sir, we are doing nothing to unfair the workers of Barbados. We're doing nothing spiteful to the workers of Barbados. You have to realize that these workers are our people. They are our relatives, they are our friends, they are our constituents. And I can tell you that on the floor of the House, in fact, to put it another way, there is a member of Parliament where these layoffs have actually walked into his house. Into his house. And yet we can hear they're doing this for the friends, they're doing that for the friends. But in the household itself. I myself, I got relatives that get laid off. Well, I don't know if you know who we're talking about. Yeah. The point I'm making, sir. The point I'm making, sir, is that we are doing nothing to unfair the workers. Why would we, in a situation like this,
I'm not sure the employers are not doing.
yeah,
taking
do
advantage.
things. Anyhow, so the other thing I'm saying is that the mood of this country right now, I think the country is in a fairly understanding mood. I have had some people who have openly said to me that they had actually expected these layoffs years ago. And they realized that the layoffs would have happened. I have listened to the Prime Minister speak on this matter. And clearly from what she's saying this, she's saying we are not stopping at retrenchment. Just sending home the workers will not solve our problem. She is saying, as a government, we will not feel that we have fully accomplished our goal until the retrenched workers are back to work and unemployment is at its minimum. I have got that from her. She is saying that we would not have accomplished our mission unless there is a reduction in the level of taxation. She is saying that we would not have accomplished our mission until the worker's dollar has more purchasing power. We are not doing anything to spitefully unfair the workers of Barbados. But we have to overcome this painful period first. You know, speaking of the unions though, I was surprised, just a little wee bit surprised, when Senator Moore said, myself and Senator Franklin are agreeing this evening. And it reminded me of a point I wanted to make about 6 weeks ago.
Take long, man.
And yeah, I had to take long because I didn't have the opportunity, but I had a note on it here. It is where one trade unionist had said that another trade union was allowing government to play with its belly like a puppy, like a sick puppy. Like a puppy, like a puppy.
Puppy is sick no more.
Yeah. Now, Mr. President, I'm not trying to stir up anymore. All I am saying, I'm the Gallus Bay, never will be. All I am saying, sir, is that to date, that particular statement by a trade unionist has dealt a big blow to trade unionism in Barbados. That statement, sir, shows a blatant disregard for the ethos of the trade union movement. It is my view that it has done irreparable damage to the trade union movement. And I don't even think, sir, that an apology can repair the damage. You know, sir, we are always told that a kingdom divided against itself cannot stand. And there's no truer motto than that when it comes to the trade union movement. I believe, sir, that it is in unity that your greatest strength lies. Trade union leaders, Mr. President, do not use this type of derogatory, demeaning, and humiliating language when they are speaking about another trade union. It is very, very divisive language. Very divisive language. And yes, I agree that I speak from experience. I have been Minister of Labor in Barbados for about 7 consecutive years. I have had my battles with some of the best, with Sir Roy, with Robert Morris, with Joe Gordon, with Dennis Clark. I have had my battles with the best, with some of the best. And I have seen them operate. I have seen them operate. trade unions do not attack one another in public. Sometimes, sir, trade unions may not see eye to eye,
You mean real trade?
but they will deal with their differences behind closed doors.
You mean real trade unionists?
I believe, sir, that trade unions need each other like farmers need the rain. But you see, sir, as I've said before, in this chamber, sometimes the urge to promote yourself and to increase numbers is so great that it overpowers the need to be responsible. I know, sir, he can sing. The senator can sing. And I would have preferred him to sing a song not designed to destroy the movement, but one designed to connect the movement. I believe, sir, that the song he should have been singing is United We Stand and Divided We Fall. I believe so, but he can sing. But he never sings that song. Never sings that song. You know, the reason why perhaps he's never sung the song is because he's more concerned with the singer than with the song. He's more concerned with the poet, with the poet than with the poem. You know, sir, there is a story, a mythology, a story in mythology, where there was this serpent with a, no, I'm not calling anybody a serpent, I wouldn't do that. With a serpent, he had one body, but he had two heads.
Absolutely.
And those two heads fought against each other and they had poison fangs, fought against each other until they killed themselves, the heads, and they killed the body too. So I just want you to remember that when you belittle and discredit another trade union, you automatically do the same thing to your own trade union as well.
Mr. President, I do not relish getting up, but he has been, Senator Walker has been attributing improper motives to me. But I understand where he's coming from, and I said that weapon that he's using is an old weapon. It was found in Judges 15:15, and so he can continue.
You see, if I may continue, sir, all I'm saying though, is that you must always remember that you are walking in the footsteps. I shouldn't even put it that way. You're not walking in the footsteps. You are standing on the shoulders of some of the greatest sons in the Caribbean that the Caribbean has ever produced. You are standing on the shoulders of great men. How can you, with conscience, compare the trade union of Sir Hugh, Sir Frank, Sir Roy, to a sick puppy with somebody playing on it with his belly? 20 more. How can you do that? Compare it with a sick belly with somebody playing with his belly. There's some people who thought that it was humorous. I had my views about it. But thankfully, Senator Moore reminded me about it this evening. You know, there's an old saying that it says that some men's heads are as easily blown away as their hats. You know?
That doesn't refer to anybody here, I hope.
But I would hope that what I have said is helpful to the Honourable Senator. And he always says that he wants to help the government. I want to help too, and I want to help him, and I hope he takes what I've said as constructive criticism. I really want to help. In fact, only this morning I was hearing is Paul Robeson, I think, was singing this song. If I could help somebody as I pass along. If I could help somebody with a word or song. Yeah. If I could help somebody who is going wrong, yes, then my living shall not be in vain. I'm obliged to you, Mr. President.
Senator Holder,
Can I am not really on, Mr. President. So, me? Thank you. Mr. President,
has she given way?
yes, well, she didn't stand up. Thank you. So, I really am not going on. Mr. President, you know my question is, what is it that we're doing tonight? As I understand it, we are, the amendment before the House is in relation to an oath or affirmation and the change of a second schedule. Senator McConney, Senator Franklin, Senator Morris, Senator Boyce, I'm not sure about Senator Greenidge. There's something wrong with the employment rights legislation, yes. But today, this amendment is to, the bill before the Senate is to deal with the oath. So what is it we're doing this evening? Why are we still here, Mr. President? Because if there's an objection to the amendment, it could only be similar to what Senator Morris spoke about. Why are we bringing such a, perhaps an inane amendment to the House, to the Senate, without bringing substantive amendments to the Senate? Because according to everybody, and I was about to say, but you can't say that in the House, right? According to everybody, I work with the Act. I work for employers. I work for employees. I am not a trade unionist in here looking for members. However, it is not in dispute that there are issues with the legislation. It is not in dispute that you are making a process of conciliation mandatory, but you're not giving the persons who have to deal with that process the power to make it work. There's so many things that can be done with the legislation, but what are we doing this evening? Everything everybody is saying gonna have to be said again, because in order for the persons who are gonna be sworn in before the Governor General to function, you gotta fix the legislation. So why are we doing it now? What are we doing? What? Mr. President, help me to understand. I tend to understand. I know I was born with blue eyes, and so sometimes I believe because they changed when I was a year, my head may not flow. But this is an amendment to allow people to be sworn in before the Governor General and to change the schedule. Why are we talking about the legislation when we know Senator McConney has accepted? She has said things need to be fixed. We are working it. Senator Moore has said that they have been given the fixations for 5 years. Why are we going into a debate as if we are dealing with the amendments when we are not dealing with the substantive? And why is the government continuing to give us amendments to make us have 10 and 15 pieces of subsidiary legislation to have to review and look at before we know what the law is? If I am going to object to anything, it would be that. Bring the oath business with the substantive amendments and let us go down the road. Because according to Senator Moore, the tribunal was put into place since August last year. They have met in plenary already, so them not being sworn in before the Governor General did not stop them from beginning to work. So it did not impact their ability to function. What will impact their ability to function is if they are sworn in before the Governor General and still have to deal with the same legislation that has sufficient flaws that can tie their hands and affect their ability to deliver substantive decisions. And as we look at it before I sit, Mr. President, everybody talking about the backlog. I would like somebody to explain to me, when you get them able to be sworn in by the Governor General, and Senator Moore alluded to make people feel good, I don't know, I'm just saying, and we fix the legislation, be it in one go, 2 amendments, 3 amendments, so we're gonna have the Employment Rights Act 2009-1, -2, -3, -4. When we do all of that, and you get it going, we got to note -20, then we have 300 to 300 and something cases backlog, right? My question is, when we get to them, how soon are we going to get any kind of effective outcome? Because unlike the severance tribunal, where you can, based on the setup, deliver a decision for the most part the same evening, how are we doing that in a contentious environment where you have to reasonably give the chairman the opportunity to receive evidence and deliver decisions? I say again, what are we doing in here tonight, Mr. President? I sum it up. Why are we here debating Employment Rights Tribunal Act as if we have amendments before us? We have one. Do we agree that they should be sworn in before the Governor General? Serious people, seriously. I'm obliged to you, Mr. President and Senator Holder. What we gonna do it?
Senator Holder?
Yeah, thank you very much, Mr. President. I give Senator Tate a few moments to speak. You understand?
5 minutes.
The old people say that all the time. You see, you ask for an inch, and you take another. You know, but that is understandable. Tonight, Mr. President, I could not sit here and not contribute to this process, primarily in defense of the administration that I represent. So whereas I understand Senator Tate's rhetorical question earlier, the fact is I have a responsibility. You know, Reverend Rogers would understand the concept of being an apologist, having studied apologetics, and I therefore need to represent Mr. President. I listened to Senator Moore. I think it is Senator Moore's contribution that would have really challenged me to rise at this late time. As I listened to her, the text from Galatians 5:7 came to mind. As Paul was speaking to the church at Galatia. In verse 7, he said to them, "You were running well. Who hindered you from obeying the truth? You were running so well. Who hindered you from obeying the truth?" I could not believe. I counted 4 at a minimum times, and Hansard can correct me. The times that Senator Moore said she agreed with Senator Franklin. I agree with Senator Franklin. I counted about 4 times. And I'm there and I'm startled. Because I understand, yes, that we are all Christians in the room and that we ought to forgive those who do evil and trespass against us. But telling me that I am allowing the government to rub my belly and all that stuff, like a sick puppy, Mr. President, it challenged me to wonder what was happening tonight. And then I remembered that Shakespeare play, The Tempest. The quote that we in modern time talked about, politics make strange bedfellows. Actually, the quote came from that play which said, "Misery acquaints a man with strange bedfellows." Yeah. Misery. And I said to myself, I wonder if it is that there is a problem in the movement. I wonder if it is that maybe the principle of one of the newest trade unions, I think it is called the Unity Workers Union, if the principle of that trade union has been poaching members from other trade unions. I don't know. I don't know. But I've been wondering if this is happening because misery acquaints a man with strange bedfellows. So, Senator Moore, I will seek to, through you, Mr. President, offer a few thoughts to what I heard tonight. Because I am sorry that you got a letter today about an action tomorrow, and clearly it has created some annoyance. And if I was to put myself in Senator Moore's shoes, I may be annoyed too. But, Mr. President, because you may be annoyed at that act or that action, you ought not now to trivialize, in my view, what we are attempting here to do tonight, so that we can conclude this matter, agree, as I believe no one will disagree, so that the tribunal can go to the Governor General and take the oath, which, by the way, all of us in here did. All of us in here went to the said Governor General and took an oath. So it cannot be that that now is being scoffed at, Mr. President. So you cannot trivialize the issue of members of a tribunal taking an oath. You cannot trivialize this amendment that will now place those who serve in this tribunal. You can't trivialize it, Mr. President, because you're appeased at some other issue that you have to confront in the normal course of your duties as a leader in a trade union. Don't trivialize it.
On a point of order, Mr. President, whilst my name wasn't called or direct reference, don't think that anyone in here sought to trivialize a member of a tribunal going before the Governor General to take an oath. What was said is that to bring an amendment that speaks only to that, when there are issues of substance that need to be addressed, and where there is a recognition that there have been issues of substance for at least 5 years which needed addressed, that is trivializing the intention that the Act seeks to protect workers.
Thank you, Mr. President. I will continue. And to offer these few points, Senator Franklin in his submission admitted, and I thought rightly so, that this current administration cannot be blamed for a number of issues that we currently have with this piece of legislation. And rightly so he said that. Mr. President, the pressing issues before us and before, I believe, the ministry with responsibility for labor are being worked on, are being addressed, and I'm going to share 1 or 2 points, so that we do not think, Mr. President, that this oath, or taking this oath, is a simple and a trivial matter. I heard mentioned earlier that the greater powers of the CLO that is being talked about, and I believe Senator Moore made this point, right? Senator Moore made this point that, oh, we're hearing about the CLO and the issues related to the CLO but there's no time frame. I can stand here, Mr. President, and indicate to this chamber, as I'm sure that other members are aware, and I believe Senator Connie has mentioned it in her preamble, that the 2019-2020 estimates include a substantial sum to strengthen the work of the Labor Department, to strengthen the work of the tribunal, to the point where they envision that at least 3 tribunals, up to 3 tribunals, can meet simultaneously to address these issues. And that, Mr. President, has been included in the 2019-2020 estimates to address this matter. So it is not an issue that this administration has turned or is turning a blind eye, or maybe not treating with alacrity the issues of labor and the relationship employer-employee and so on. It is not a case where that is happening. That's one. The vote to ensure that the monies can be provided for the tribunal to meet, to have the administrative support, and up to at least 3 of them can meet simultaneously. I think it is Senator Boyce I heard before with that quote, "This is good legislation." The fact is, Mr. President, this is bad legislation. What we inherited is bad legislation. I think maybe one of the earlier speakers might have alluded to it. He didn't use that language, but it's bad legislation. It has a number of issues that need to be addressed. And yes, this administration now, like with so many others, is tasked now at addressing these issues, Mr. President, and we will address them, Senator Tate. We will address them, as we have been doing so with so many others. We will address them. The fact is, here I have, Mr. President, in my hand, a 14-page document dated November 2015 from the Barbados Employers Confederation, followed by a subsequent letter this year, last year, 2018, that continued to repeat the myriad of issues that need to be dealt with this piece of legislation. The last letter was June of last year, 1 month after the election. And I think, Mr. President, in fairness to the Ministry of Labor, that there have been meetings, I understand that there are several sessions, plenaries, and so on, looking at regulations for this act, because there are no regulations. I understand that they've been looking at models, they've been looking at Turks and Caicos and US models. Huh? Yes, Turks and Caicos and others, looking at regulations for this, because there are no regulations in place, Mr. President. You know, the Barbados Employers Confederation, in their letter, their most recent letter said, and I quote, "In seeking to protect employees from arguably a few unscrupulous employers, we fear that the Employment Rights Act has facilitated an environment where things have moved from too far east to too far west." This is the most recent comment. And earlier, they've also made the point, Mr. President, indulge me, and I quote again, that one would agree that since its enactment, this is the EIA, many of the shortcomings expressed by commentators in both the employer and union settings have come to pass and have shown the need for change. Now, why did I introduce that, Mr. President? To suggest to us and to show us that this act has been problematic from inception, and that this current administration is now seeking to address it. And to also indicate that over the last few months since the May general election, that there have been several meetings and consultations, etc., to treat to this and bring this, as we have done with other pieces of legislation, into what Senator Sands would call the 21st century. Now, I hear the side comments from members that would suggest, well, bring it now. Why is it taking so long? It bothers me, because I know that the leader of opposition business in the Senate oftentimes argue that we are rushing things. We are too
Going too
fast. We're not taking our time. We are bringing too many bills and not going through thoroughly, and they're coming with errors and blah, blah, blah. I've heard this so many days, our 15th sitting. I may have heard it 14 times. I said I may have heard it 14 times. I don't have to be here, Mr. President. I watched the videos, the 2 sessions that I missed in December.
So I hear it all the time. Right? So you're complaining on one hand that we are rushing, we are moving too quickly. When we want now to ensure that we address this matter of workers' rights and employers' rights correctly, appropriately, thoroughly, Mr. President, we're hearing tonight that having an oath and for the tribunal members is a trivial thing, and instead of us focusing on more substantive issues. Mr. President, I don't wish to keep us too long, but I have to address these matters, Mr. President. First one, I talked about the CLO, the Chief Labor Officer. I mentioned that. The Chief Labor Officer I felt as if he was being pilloried earlier. Pilloried by a member. I felt as if he was being pilloried. I'm going to stand here, Mr. President, and defend the public sector workers of this country, Barbados, for as long as we could recall, pride ourselves in having competent, well-trained civil servants. We're not saying that there aren't one or two, Mr. President, that have maybe let us down along the way, but arguably, the point has to be made that we have competent civil servants, persons that we can be proud of. And therefore, what I know that the Minister of Labor is considering, and I believe may have been mentioned in the other place, is a review of the roles and responsibilities of the Chief Labor Officer and the department overall to ensure that they're able, Mr. President, to address a myriad of issues that do not have now to go to the tribunal, that they can deal with some of the less complex issues without them having to escalate to the tribunal. So I know that that is being worked on. The other point made by Senator Greenwich, which I tend to agree, that you don't want the tribunal to have such a legal face that it comes across like a court. Huh? You don't want that. And so, not only do we need to give them the financial support for the administrative and other responsibilities, but I think that we have also, Mr. President, to maybe look at and rethink the cases that are presented before the tribunal. There are, I believe it is Schedule 4 of the current act that deals with disciplinary issues. That tends to be a bit vague. The language is not clear, is not clearly understood. And again, the Barbados Employers Confederation and other stakeholder groups would have written on these matters saying that, look, the language here is a bit ambiguous at times. You're not clear. And should it be a case where all issues go before a tribunal? If an employer wants to have a disciplinary hearing just to address maybe a verbal warning, does that have to go before a tribunal? So it is not clear. There are things, therefore, that need now, Mr. President, to be looked at and to bring some level of rationalization to. We agree that is being worked on. Also, the point was made about the length of time that it takes persons who have been summoned to actually appear. And some, for whatever reason, whatever intentions they have, whatever is their motive, tend to delay this process by not showing up, not appearing before the tribunal, sometimes without reasonable cause. And the point has to be made that just maybe we need to look at rules. I know the regulations are being considered. Maybe we need to look at rules that the tribunal or minister can enforce to address those situations where persons do not appear and without any reasonable cause before the tribunal. And matters keep going on and on. There's some matters that have been there now for years. These are issues Mr. President, that we believe can be addressed even outside of the full amendments that we are calling for and that we recognize are needed to this piece of legislation. And Mr. President, I can go on
Please don't. No,
and on. I am mindful of the time, but I would also remind persons that I wasn't here on December 19th.
don't make up for it.
So I didn't get to make my contribution in the wee hours of the night. But I take your counsel, Mr. President. I will not see the makeup for it at this time. But I will conclude. We can conclude with these comments as I started to suggest that yes, this amendment this evening is a simple one. It is not an amendment, Mr. President, that I thought, quite frankly, would have had such robust debate and interventions by so many people. I didn't think that, because it is such a simple amendment. And as Senator Boyce rightly said, it has its basis in law. It has its basis in law. So I could not therefore understand, Mr. President, why this issue would have been such a contentious one, and felt therefore that I needed to stand at this time and represent this administration, who we recognize, there's no one that can say otherwise, that since May of last year has been doing all that it can to steer this ship forward, bringing back this ship of state, that is, bringing back this country from a near collapse. From a near collapse. It is unfortunate, Mr. President, all of us in here, I believe, we're joined in chorus that we don't want to see anyone go home. Who wants to? Who wants to? No one wants to, Mr. President. No one wants to. There might be one individual in particular who relished the thought of getting more and more members as a result of what may be happening, but no one relishes the thought, Mr. President, of anyone going home. But what is the fact? You know, I feel each time I speak, I have to remind us of certain realities. Mr. President, $600 million represented the gap that the government had to close, has to close. Mr. President, you know what $600 million represent in wages?
Yes, he does.
And emoluments? You're aware? It represents, they tell me, about 20, it represents about 20,000 persons. It represents about 20,000 persons. Can you imagine if this administration made the decision that it will levy this solution onto labor? What would happen? But instead of 20,000 workers approximately, the Prime Minister sitting with the social partnership, meeting after meeting after meeting, Mr. President, was able to put the case that it is not only labor that will participate in this process. We will try to restrict it to 1,500, but it's not only labor. Capital will also play a role. Capital will also play its part so that we can close that gap of 600 million, Mr. President. So no one wants to see anyone go home, but the reality is we have to pull this ship of state back from the brink. Mr. President, I support, as simple as it may seem to some, I support this amendment. Mr. President, simple things are sometimes only appreciated by simple minds, and only defined so by simple minds. But I don't think that this is just a simple amendment. I think that this represents something significant. It may not be substantial changes to the act and to the legislation at this time, but it is significant nonetheless to bring those who will serve within our space on the tribunal, to bring them to the level of accountability and so on that we have been talking about, that has been characterizing this administration. So, Mr. President, with those few words, I'm obliged to you.
Senator McCartney, are you going to wind up?
Thank you, Mr. President. You know, Mr. President, the occasion of this simple amendment to introduce an oath or affirmation to members of the Employment Rights Tribunal has created space for a very essential dialogue on matters that matter to people deeply. And we see how deeply it mattered because it is reflected in the enthusiastic contribution of Senator Franklin on behalf of his constituents. It's reflected in the plea of Senator Greenidge not to make the tribunal too legalistic. It is reflected in the history of oaths from Senator Boyce that established the legal basis for this proposed amendment. It is reflected in the animated presentation of Senator Tate and in the level-headed presentation of Senator Holder, and indeed in the impassioned contribution of Senator Moore. And it is a sign of maturity, Mr. President, when we can have open dialogue on difficult matters, when we can acknowledge where there is need to improve, whether it is in more resources, it is in less delays in arriving at decisions of the tribunal, whether it is a need for us to improve in regulations, or, as I would have said, where there is a need for us to improve not only what we do, but how we do it. And it is unfortunate that Senator Moore felt embarrassed, for indeed I felt proud that we have reached a place in our national conversation where we can agree on what we need to do better and how we need to do it better. And so, with those words, Mr. President, I commend this proposed amendment to Section 6 of the Principal Employment Rights Act in the interest of introducing an oath or affirmation to members of the Employment Rights Tribunal. And with these few words, I again beg that we read this bill a second time.
The question is that the bill under consideration, the Employment Rights Amendment Bill 2019, be now read a second time. All honorable members in favor, please say aye. Those again, please say no. We think the ayes have. You will say it now to committee. Move it into committee now. Move that I know upset myself.
Mr. President, I beg that you now leave the chair and the Senate resolve itself into committee of the whole for further consideration of this bill.
Question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of this bill in committee. All honorable members in favor, please say aye. Those against, please say no. We are now in committee. Over to you, Mr. Chairman.
I don't support it. I got a case before the employer. That fella, I had a case. He got cases, he claimed he got cases. He claimed he got cases. Sorry, man.
The Senate is now in committee.
I said they got 2 against you.
Clause 1. Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that Clause 3 stand part.
The question is that Clause 3 stand part. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it. Report the passing of one.
Mr. Chairman, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill be now read a third time.
Question is that the bill under consideration be now read a third time. All honourable members in favor, please say aye. Aye. Those against, please say no. You think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Employment Rights Amendment Act 2019.
Question is that this bill do now pass and be so cited.
Yes, senators. Honourable senators. I thought we were going to ask the senators. What did?
No, yeah, well, just to finish. All those in favor, please say aye.
Aye.
Those again, please say no. You think the ayes have it? The bill is now passed and will be so cited.
Mr. President, this brings us to the end of our business for today, and I want to beg to move that this Honourable House be adjourned until Wednesday, the 6th of February at 11 a.m.
Wednesday, the
6th
6th
of
of February.
February.
The question is that
Happy birthday.
this session be now adjourned until Wednesday, the 6th of February at 11 a.m. All honourable members in favor, please say aye. Those against, please say no. We think the ayes have it, and we are now adjourned.